Welcome to the Bar Exam Toolbox podcast. Today we're discussing how much law you need to include on your bar exam essay questions. Your Bar Exam Toolbox hosts are Alison Monahan and Lee Burgess. That's me. We're here to demystify the bar exam experience so you can study effectively, stay sane, and hopefully pass and move on with your life. We're the co-creators of the Law School Toolbox, the Bar Exam Toolbox, and the career-related website Career Dicta. Alison also runs the Girls Guide to Law School. If you enjoy the show, please leave a review on your favorite listening app and check out our sister podcast, the Law School Toolbox podcast. If you have any questions, don't hesitate to reach out to us. You can reach us via the contact form on barexamtoolbox.com, and we'd love to hear from you. And with that, let's get started.
Welcome back to the Bar Exam Toolbox podcast. Today we're talking about how much law you really need to learn for the bar exam, and also what the ratio of law to analysis should be for a passing essay. And I saw an actual essay answer the other day. Somebody sent it to us to look at, and it was probably 80% law. It was basically just a rule dump. It was definitely not a passing essay because they really didn't use those rules at all. And this to me was a very interesting example because the essay itself was a UBE question about evidence. And in my mind, you don't really actually need to write a ton of rules on the average evidence question. It's more about having this clear process to determine whether the evidence is admissible, and you have to go step by step. So for example, you might write the basic rules and then apply them methodically to each piece of evidence, and then you might have to add some additional law if something applies specifically to that item. So for example, my attack plan for evidence might be, is this relevant? Explain why. Is it more probative than prejudicial? Explain why. Is it hearsay? Explain why. Does it fall under a hearsay exception? Explain why. And so on. So this got me thinking more broadly about the ratio that you want to see of law to analysis in an average essay. So Lee, what do you think about this question?
I think this is a really important point and something that people really don't focus enough on. And I think that's because the typical bar review course spends the majority of its time just focusing on learning the law. So let's say you're taking one of the major bar review providers. You're probably listening to about 20 hours of lectures a week on average, probably.
Yeah, seriously,
something like that. It's a lot. And so because you're spending, let's say half or almost half of your study time just listening to lectures, and that's not making your own outlines or studying the law after those lectures, it almost becomes this idea that you need to know all of this law, that this law is by far the most important piece of the bar exam. And it turns out, if you actually read the directions that come with the packet of essay questions, which almost nobody does, it usually mentions analysis a lot more than it mentions rules. And that's your first clue that the analysis is really what's the most important. And when you take a step back and you think about it, that makes sense, because if you want to practice law and you're trying to prove that you are ready to be a lawyer, anyone can look up the rule. These rules aren't secret. It's like if you need them in real life, lawyers look up the rules all the time. So anyone can look up a legal rule. Anyone without a legal education can look up a legal rule. What's supposed to make us lawyers is the idea of issue spotting, the correct issues from the facts, and then applying those facts to the law in the correct way and understanding how the law is applied. Well, if that's what makes us lawyers, then that better be a huge chunk of your essay. That's not exactly how the bar review companies present it, I think. I think they present it as very law forward, and then students forget that it's really, your scores are analysis forward, I guess is the best way to say.
Yeah, I think that's a great way of putting it. I mean, if you think about it, you can probably actually just Google a lot of law, particularly anything statutory. I can just type in California evidence, hearsay, and I'm probably going to get the rules. It's not that complicated. I mean, granted, you have to sort of memorize some stuff. It's not super easy, but that's not really evaluating your legal judgment. That's just legal information. Yes. And I think, in addition, I completely agree with you on this emphasis. I mean, we talk to so many people who fail, and they're like, well, I basically watched a lot of videos, and it wasn't really that helpful, but that was what the schedule said to do, so that's what I did. People also, I feel sometimes they want to show off their legal knowledge to the graders because, you've spent, let's face it, tons of time and energy learning this stuff. You want to show that you learned all of it, not just, it's not I need to only use the 10% of this evidence information that I have in my head to answer this actual question is like, oh, I'm going to give you everything,
Right.
Let me
everything
give you
in the
all,
kitchen sink. So
yeah, let me list out, for example, like 18 hearsay exceptions or something. And then I'll consider which one might apply. But the problem is you don't have time for that.
Yeah.
And you have to really apply these rules, not just write them down. Like maybe you get a tiny bit of credit for writing down, but you don't get any credit if you're writing down a hearsay exception that is totally irrelevant.
So I think one of the things that people forget is that although you need to know the rules to pass, the bulk of each essay has to be your analysis and conclusion. And one of the things that we see happen, and I get this feedback from students too, is they oftentimes will score the best on the subjects that they know the least about. So,
oh yeah, I hear that all the time.
So
like, I couldn't believe my score on community property. I barely knew anything. It's like, yes, you knew just enough to actually have to do the analysis over the course of an hour. You weren't busy writing down. I mean, certainly I think, the subjects that say people are practicing attorneys and things, they often do horribly in the things that they practice in. Because you know too much.
Exactly. And you're making it way too complicated. The bar can only be so complicated, to be done in a certain amount of time, 30 minutes or 60 minutes, depending on your jurisdiction. So that always really tells us that what you really need are the basics of all of these rules and the basic application of these rules. The deep dive into the nuances of evidence law is not going to get you any closer to passing, especially if that deep dive or that everything in the kitchen sink approach ends up wasting a whole bunch of your time that you needed to spend using analysis and issue spotting. You won't pass. You could have the best hearsay analysis ever, but if the question also was about prior bad acts and you never talk about prior bad acts, you won't pass.
Exactly. Yeah. And I mean, frankly, you're probably not going to pass an evidence essay if you don't go through the basics of like, why is this relevant?
Right. Yeah. You have to check those boxes.
I mean, it seems obvious, but it's got, even saying something like, this piece of evidence is relevant to the outcome because it helps us determine if the light was green or red.
Right.
I mean, that sounds basic, but if you don't write that down, you're probably not going to pass the essay.
Right. Exactly. And even in California, they test California evidence and the federal rules of evidence on the essays, and the rules for evidence are slightly different, mostly in language, I think, than in application. And so again, like the rules aren't complicated. You just need to know what that difference is and then apply that difference.
Yeah, exactly. So I think in order to be able to do this, people have to start to really have a different mindset about preparing. Do you agree with that?
I do. And really take a step back and think about the legal rules that are really necessary. You really have to break them down and think about them as elements and think about the rule necessary to do the analysis. So if you practice and your rule statement is an entire paragraph long, and then your analysis is a sentence or two long, it's important for you to go back and say, hey, what was in that paragraph of that rule statement? Like what was necessary in there? Because probably a lot of that was unnecessary.
Yeah. And I really think whenever people are doing practice questions, you actually want to look at, did you talk about every rule or even every element that you wrote down? And if not, why not? Did you include unnecessary rules or elements? Or did you accidentally leave this out of your analysis? Like one of those has to be true.
Yeah.
Because anything that you write down, you want to be using. So I think that's like don't write extra stuff. You don't have time to be writing extra law and you're not going to get credit for it. So I completely agree with you about the elements. I think thinking of, what's the shortest rule statement you can possibly memorize that is complete is a great way to look at it. There's no point in trying to memorize more stuff than you have to.
Right.
So if you can break it down into some sort of element by element analysis, that's what you need to memorize. And you probably actually can memorize that if you practice it enough.
Right.
So in addition to kind of learning through or thinking about these elements, I think one thing people can consider is instead of just sitting and kind of passively absorbing material, to really try to learn this law from practice.
Yeah, exactly. And testing yourself through the practice and practicing writing it down in the way that you're going to have to recall it on the essay. I was talking to a foreign trained attorney this week about one of the things that foreign trained attorneys struggle with. And, they struggle with oftentimes crafting language because English may not be their first language. And even though they might be used to conducting business in English, you usually don't have to do it in the same sort of time pressure as you have to do the bar exam. And so you have to verbatim memorize rule statements because you don't have time to think, how am I supposed to present hearsay? What were you have to just know those rules cold. You need to know present sense impression and write it down the same way every time. But I think all bar studiers benefit from that type of study. If I ask you, Alison, what's the rule for present sense impression? Your answer should basically be the same every single time. You should.
And my answer would be like, I'd have to go look that up for you.
Well, you're not sitting for the bar right now.
Exactly. I can guarantee you when I sat for the bar, I did know the answer to that question, and I could have told you word for word what I would write down.
Yeah. And, if you don't believe us, I've been doing some exam question reviews as part of this podcast. And then we also have a program that we offer through the Bar Exam Toolbox called the Writing of the Week program, where we walk through essay questions, both for California and the UBE. And every single time I do one of these exercises, and now I've done a lot of them. I think we have 20 some MBE ones. I've got like 15 or some California ones. I've written a lot of these. And every single time I do it, I have a moment where I'm like, wow, that's really not very much law tested on this question every single time. We've been working on this project for years. I think we started the Writing of the Week program. And every single time I'm still surprised at how little law is necessary to know to execute a given question. And that is such an important realization.
I can definitely attest to that. As you know, my California substantive knowledge was very limited when I took the California bar. It was, I literally didn't realize they tested professional responsibility.
Huge mistake.
Like, already took the MPRE. Why would this be on the test? Yeah, bad assumption. It's always going to be on the test. But I literally didn't know. I certainly didn't know the law like that well. I knew some stuff, but I passed. It was amazing.
Right. Yeah. This is also why something you'll hear a lot, especially in the California bar, but I think for all bars, is if you don't know the law, you can make up the law and then apply it correctly and still get a majority of the points. And that is so telling because I did that on my bar. I may not have passed the question. There's no way for me to know because those scores are buried deep in the California bar exam vaults.
Exactly. They do it's really too bad. I honestly think if I'd only done the essays, there's a pretty high likelihood I would have failed. But yeah, same thing. I didn't remember like the distinctions of California evidence versus federal evidence. I knew there were two rules. Mm-hmm. Did I know which one was which? No, but I just picked one. And they're probably like, oh, well, she mixed up California versus federal, deduct a little bit, but whatever. She basically understands it.
Yeah. I have a dear friend who applied the UCC instead of the common law to a contracts question. That was a huge mistake. She still passed the bar. There was a question that I don't think most people in the room knew the answer to on the bar that I took. And because I went back and it wasn't even the Barbary outlines. And so we all made up law. It was like, I was like, under Article 3. I was just totally making stuff up.
I'm guessing on this most recent test, a lot of people were really digging deep on what they remembered from first year con law or second year con law about the Dormant Commerce Clause.
Oh, yeah. And in
California. And I'm guessing not that many people really had that law exactly top of mind.
No, and it is a gnarly question where one of the things our team does is we all take the bar for fun, woohoo, during the off season. So we have gone through all the questions on the recent bar. And that one, the whole team kind of got together and was like, like we better talk about this one. There was a lot of head scratching going on.
Definitely like, okay, so I remember we covered this. So does anyone remember this?
I know, we're like digging deep. So yeah, there are lots of those questions that come up. And, the thing is, these basic rules of law, you can study for all of these months, but it is very likely there's going to be a point on your test that there's going to be something that you don't know anything about. I think what happened on my exam was a great example. That law wasn't even in the Barbary books. And most of us had taken Barbary. I can't remember what market share Barbary had back then, but it was
a lot.
It was almost everybody.
Basically, if they didn't teach people, then probably like 80 or 90% of the people in the room were like, yep, not in my head.
Right. And I had taken federal courts. I had taken, I was a very high scoring in my con law class, still had no knowledge of this law, had no idea. And that's just going to happen. And that's, again, though, an example of why you can't make yourself crazy trying to promise yourself that you're going to know every piece of law that is out there, because you might still be stumped. And so what you really need to focus on is issue spotting from the facts, and then hopefully knowing the correct law, writing it so concisely and cleanly and in a way that can easily be applied to the facts, and then argue about the facts, because that's what lawyers do, and then conclude with confidence, and then see how many points you get.
Yeah, and I think sometimes, I mean, in these scenarios, you can actually kind of almost extract like what the law is likely to be from the facts.
Yeah.
You know, if like, I mean, I'm thinking of like the Dormant Commerce Clause example. Like maybe you have like some vague memory of basically what that kind of is, but you certainly don't have like element by element. But I'm guessing if you read the essay, it's probably going to clue you in to certain things that you need to be thinking about. And from that, you can almost extrapolate what the law probably is. And again, like you just write that down and apply it. But that's a great example where if you think that 80% of your essay needs to be on the history of like constitutional law, A, you can't do that because you don't know it.
Right.
And B, it's not what we're looking for anyway.
Right. And this comes up all the time. There was a question a few years back that involved a checkpoint. This was a criminal procedure question. And it was like police stopping people. I believe they were walking. So it was like a walking checkpoint, which is not typical. It's usually a driving checkpoint, like a DUI checkpoint. And they gave you a lot of facts about this checkpoint. And there were a lot of people who ignored the checkpoint because they didn't know what the law was for the checkpoint. I don't know.
I love that.
And I didn't know the law for the checkpoint either. If that had been my test, I would not have known the law for a valid checkpoint. There law?
Yeah, I'm like, I don't even think can you even do that? My guess is you can't even do that.
Like, well, I mean, you can do DUI checkpoints. Those are legal.
No, but I'm saying, but here would be my argument on this. If you gave me this question on the bar exam, I would be thinking, okay, I know that in certain cases, DUI checkpoints are legal. Why is that? Okay, probably because we don't want people driving drunk. Okay, that's a valid policy reason for doing this thing that's kind of invasive.
Right.
And then maybe I remember some other rules about it. But then I have to then apply that, extrapolate and say, well, who am I a danger to if I'm walking drunk? That's a different policy consideration. Okay, so that's probably going to fall on a different side of the line of like invading my personal space. And then maybe I'm thinking about, stops on the street and that kind of thing. But yeah, I have no clue what the actual law is on this.
So like you said, I mean, if you were making up law about a checkpoint, a good option would probably be there's some sort of it's always, that's a constitutional right? If you're violating someone's constitutional right or you're infringing on the right, there's usually like a balancing test, the public interest versus the personal interest. And then maybe there's reasonableness of the actions, or, maybe it can't be about a specific person, so they can't do profiling. I mean, you can come up with kind of all these things and then see like, well, what facts do they give us? Was it very routine, or were the cops like pointing out just people of color, people dressed a certain way?
Maybe it's only in certain neighborhoods that they're doing this,
exactly.
Not other neighborhoods. What are the characteristics that you're told about those neighborhoods?
Yeah, and so you can kind of come up with a pretty good law story, even if you're wrong. But the law that we've just been, brainstorming about with the checkpoints, you could still argue based on that law. And even if you're wrong or slightly off, some of the things in your analysis will probably be right. Because one of the other things that I think happens in the bar exam is you have studied so much law that you have a pretty good gut reaction on what a reasonable rule would be. And I think a lot of people don't give their guts credit for that.
Yeah, I think that's right. I mean, you're probably not starting from scratch on this. I mean, you have studied a lot of like other checkpoints. You can probably extrapolate. And if you've done all of your bar preparation and you're thinking, I have never in my life heard anything about this law, like where is this coming from? It may not even exist.
Yeah, I mean, or it exists as a nuanced rule that may not have even been in your outline. But your job is to still identify that issue and say the checkpoint is an issue. So you need a header that says checkpoint, underlined, maybe bolded as well. And then you need to have a rule. And I don't really care what that rule is. If you don't know the rule, then you make it up, but you don't say, I am unsure of the rule. You literally say, police are allowed to have a checkpoint when they have reasonable, whatever.
Right,
and
exactly.
Then
you throw in some buzzwords that seem like, okay,
Yeah. And then it's like, if you decide that it has to be reasonable and maybe it has to balance the individual's interest under the public policy, the reasons for doing the checkpoint, public policy safety, then you could do a balancing test. Something in there might be right and you're still going to get points. Ignoring the rule completely, Ignoring the issue gets you 0 points. Failing answer. Saw answer after answer of that question that failed because they ignored the checkpoint.
Yeah, you should never ignore. I mean, I think that's a common temptation is people kind of freak out, and maybe not even totally consciously. They might just freak out subconsciously and kind of ignore or gloss over the fact that this is a sidewalk checkpoint because your brain is saying, oh, that's really weird. Really weird. I don't know what to do with that. Okay, I'm not going to talk about it.
Right.
That is not the correct response.
Right.
Like if you're getting the I don't know what to do with this, that probably means it's actually a pretty major issue.
Yep. I think that that's absolutely true. So this balance of when you're thinking about the law and analysis in your essay questions, and you might be sitting here thinking, okay, well, so you're telling me I'm not going to be able to learn everything that's going to be on the test. That's true. That is exactly what we're telling you. You're probably going to get stumped at some point on the test. Happened to both of us, and we both got licensed. You got licensed multiple places. So
indeed, and with very little actual information in my head.
So, but
I do clearly remember also in Massachusetts, the first bar exam I took, they gave an entire essay on, it was about Massachusetts discovery rules, which God knows I had never even looked at. But it was literally something along the lines of what you could do to try to make if you should be polite when writing a letter to opposing counsel and stuff like this. And I'm like, okay, I can work with this.
Yeah.
I have no clue what the actual rule says, but I can probably make something up that seems reasonable based on the fact that they clearly wanted me to talk about being an ethical attorney.
Yeah. So when you're thinking about this and the idea that there's probably going to be law that you don't know on the test, but then how do you make sure that you are ready for the law that you should know on the test? And I think that it comes from a few different ways. One, if you feel like your commercial bar materials are too overwhelming because the rules are so long and cumbersome, or the outlines are long and cumbersome, and you cannot memorize them in a concise fashion, then you either need to make your own materials or you need to purchase more concise materials. And along those lines, things that we talk to our students about are lean sheets, which are very lean. So some people find them too lean, but you should check them out. Smartbarprep.com has some good outlines. They're not quite as lean as the lean sheets, but they're leaner than a lot of the big commercial bar books. I also think in California, baressays.com does a nice job on substantive outlines as well, and has, leaner, more precise outlines for memorization. So you need something that's going to help you memorize the law. Now, all rules are not created equal because some of them show up more often than others. So the next piece of that puzzle is understanding what is tested and practicing what is heavily tested. And that's one of the things that our Brainy Bar Bank tool does, is we have taken all of the essay questions from many, many years. We have categorized them by subject and by topic. And so you can figure out what are the most heavily tested topics and legal issues within each subject. And let me tell you, you better know those cold. There's no excuse.
Yeah. And it's also really interesting. I think we have some blog posts on this. But if you go and compare what the UBE test versus what California tests, they're not the same.
Right.
So you can actually get pretty strategic here. And make sure that you're given the time available, make sure you're really focusing on those heavily tested rules. I mean, I think it would be a rare evidence essay, for example, that does not touch on hearsay.
Exactly.
There are just certain things where it's probably going to come up.
Yeah. And I think once you look at kind of these frequency lists where you can see the more heavily tested topics, you're kind of like, oh yeah, if you've done any practice, you're like, oh yeah. Okay, I've seen, conflicts of interest does seem to come up in every single PR question. And it basically comes up in every single PR question in California. And so you better know that rule cold because you're probably going to see it. And I think that if you have a comfort level with everything that is going to be really likely to show up on that test, that is a pool of law that you need to be comfortable with, then the rest of it is gravy. And then you make up what you don't know.
Yeah, exactly.
And that should be enough.
And I think too, for me, I think some of these subjects are more formulaic than others. Mm-hmm. So there are a couple of subjects. I'm thinking, for example, evidence, community property in California, things like wills and trusts, where oftentimes you're asked to analyze multiple items of the same type.
Oh, true.
So, it might be things like, there are basically 8 pieces of evidence that we want to get in, analyze each one of them.
Right.
Or community property, there are X pieces of property that we need to dispose of, or same thing with a will. So with these type of things, I think you really need to be sure that you have an attack plan for how you're going to go through each of those pieces of evidence or pieces of, sort of items of information, whatever they are, whether it's evidence, whether it's property, whatever. But your essay is going to be basically like analyze a bunch of this stuff in the same way. True. And so it doesn't do you a lot of good to write down huge amounts of law. You really just want to write down what you need and then go through each one in a very systematic way, and you're likely to pass.
Yep. And then say see above for rule if it's the same exact
Right. That's
rule.
actually, yes, talk about that, because people are sometimes not sure what to do if they need to repeat rules to use them in their analysis.
Yes. So please, 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 no one listening to the podcast should ever use copy and paste under essays, bar essays. They do not like it. The graders do not want to see a copy and paste rule statement. So let's take evidence, which is a great example. If you have 5 items of evidence, you are likely going to have to do a relevance analysis for all 5 of those pieces of evidence. Do not rewrite or copy and paste the rule for relevance or the rule for probative versus prejudicial. I mean, they get it. Like they've seen it before. And it just,
it's like we don't need to talk about 403 in every single piece of evidence.
Right.
I mean, basically, you want to have like your sort of, okay, I recognize this is an evidence question. Let me write down, the basic 3 or 4 sentences about like, what I'm going to need to analyze. And another thing I think sometimes people do is they want to put everything in like that initial rule statement, but that's not a great idea typically. Like,
no.
If you say, for example, you have something that's a present sense impression, and then you have something else that this and that, like, or the hearsay exceptions, you're going to be talking about different hearsay exceptions with different pieces of evidence. So you don't need to write all of those at the top, like write them where you're going to use them.
Exactly. So an evidence question could be organized as piece of evidence number 1, relevance, rule for relevance, whether or not this is relevant, conclusion, probative versus prejudicial, do that analysis. Then hearsay, what is hearsay? And then you may have 4, possible hearsay exceptions. It's an admission. It's, yada, yada, yada. Okay. Now you get to the next one, and then you might have to start with relevance again. So then you say relevance, see above for rule, period. 1 sentence or so of analysis, 403, probative versus prejudicial. 1 or 2 sentences, done, see above for rule. It's what you don't want to do is pad your language and waste time like typing out all this other stuff, because from a grader's perspective, who's grading your work very fast, they are like, great, they know the rule for relevance. They don't want to see it again. You're not getting any more points.
Yeah, I mean, literally, there is absolutely no point to including that again.
No.
You've already gotten whatever points you were going to include.
Right. You might have to include the analysis for relevance, but you
definitely, yes. You need to do the analysis. You do not need to write down the rule again. It just makes everything longer. It makes it harder to find. It annoys the person who's grading it. And there's no logical reason to think that you're going to get double points if you put the same rule twice.
Right. And your point about making sure the rule is part of the kind of issue sandwich, let's call it, because it needs to be next to the analysis. It can't be up at the top. So I think hearsay is a great example. So hearsay, the evidence has to be offered for the truth of the matter asserted. Here, the evidence is offered for the truth, therefore it's hearsay, and it's inadmissible unless it falls under one of the exceptions. Then you should not then continue. There are 4 possible exceptions: present sense impression, excited utterance. Like, there should not be a paragraph of rules. It should be number 1, present sense impression, rule statement, analysis, conclusion. Number 2, excited utterance, rule statement, analysis, conclusion. That's how it should look. Is that cumbersome, or do you not want to write that way, or would you not do that in practice? I don't really care. That's what the graders want. I mean, it
just makes it easy to check off. Basically, the check box, they're looking to give you a check, and that check is, do they know this rule? Did they do this analysis? Did they get basically a reasonable conclusion? If that's all right beside of each other, it's way easier to give you that check mark than if 2 pages ago you mentioned the rule.
Right, because they're reading so quickly. A couple of minutes. If you've never read your essay in a couple of minutes, I dare you to do it, because you are going to be shocked at how little you can cover. They're not going hunting for anything. Like they're not going to go hunting for your present sense impression rule that might be on the page before. They want it to be right next to the analysis so they can say they got present tense impression, they know the rule, they did the analysis, they concluded, let's move on. Maximum points, done.
Yeah, make it easy.
You make it easy. Make it.
And the good thing is, it's actually like, it's kind of an easier way to write. I mean, it's not very interesting, it's pretty tedious, but it's not that difficult.
No, and really, if we go back to like kind of law school 101, when you read court opinions that are well written, they are typically written like this because, they don't like discuss a lot of law and then have it be very far away from the analysis. And that's probably because people, one, need to quote things, but two, they edit cases and you get excerpts. Like, I think if the judges wrote that way, we would have to read the whole case, and who'd want to do that?
Yeah, and I think the key takeaway is like, talk about one thing at a time.
Yeah, be methodical.
Be methodical, one step at a time. Give us everything we need to know for this one point, and then conclude and move on to the next point. I mean, I think that type of logical thinking is really what you need to do to write a passing essay. And for some people, that's, it's very garbled up in their head, and a lot of that has to do with how they've learned the law. So I think if you learn the law in a more methodical fashion, this is going to be a lot easier to do.
Yeah. So I know we're almost out of time, but if you don't believe us, and that's okay, we feel like we know what we're talking about. Lawyers. We understand that it's easy to be skeptical. You can go find some of the other podcast episodes we've referred to where we walk through Californian UBE essay questions, and you're going to see our very important point of how the law is not the largest part of your answer, and it is not even, maybe could be argued, the most important part of your answer, and it's actually not a very long list of what you need to execute an answer. So that may just change your perspective on what these essays are, and maybe it'll change how you study. But the other thing I want you to think about as you study is to constantly be checking in with yourself on what's your end game. We talk about this on the Law School Toolbox all the time. You have to know what your exam looks like, so you're making sure you're studying for your exam. And I think that really this idea gets lost on the bar exam, that you are studying for this test. So I don't care if you know everything about community property and you're going to be an amazing family law lawyer. Like, doesn't matter. It only matters that you know the law as tested on the California bar.
Yeah, exactly. And this is an artificial exercise. This is not like life as a lawyer. So just accept it as an artificial exercise, learn the material in the way that's going to help you execute on the exam. And then, I think if you're looking for ratios, which we mentioned earlier, I would say, my guess is like maybe 20% of what you're actually writing is law, and the rest of it ought to be analysis.
Yeah, I think that could be right. Depending on the question, it might be a little higher than that, but
20 to 30.
Okay.
I'll give you 30.
That's fine. I can take 30. For those of you who are freaked out by numbers, you can also just say there better be more analysis than rule statement. So if you are self-evaluating your work and you say, wow, that paragraph of rule statement is really long, but I only have one sentence of analysis, that is a red flag. So
yeah, that is probably not the right ratio.
So you don't even have to worry about what the ratios are. It should be just like law should be less than analysis.
Yeah, I think that's a good takeaway. All right. Well, with that, we are unfortunately out of time. We'd like to take a second to remind you can check out our blog at barexamtoolbox.com, which is full of helpful tips to help you prepare and hopefully stay sane as you study for the bar exam. You can also find information on our website about our courses, some of which we mentioned, tools, one-on-one tutoring as you study for California or the UBE. And if this is like an interesting topic, I would really encourage you to look at the Writing of the Week program, because this is literally what it does. If you enjoyed this episode of the Bar Exam Toolbox podcast, please take a second to leave a review and rating on your favorite listening app. We would really appreciate it. And be sure to subscribe so you don't miss anything. And if you're still in law school, you can check out our popular Law School Toolbox podcast as well. If you have any questions or comments, please don't hesitate to reach out to Lee or Allison at lee@barexamtoolbox.com or allison@barexamtoolbox.com. Or you can always contact us via our website contact form at, you guessed it, barexamtoolbox.com. Thanks for listening, and we'll talk soon.